Assalamualaikum and very good day. My name is Amir Zafri bin Ahmad Tramizi, and our topic for our case study is the Trail Smelter case under the subject of public international law. Together with me is Anwar Muhammad Luqman Hakim bin Anwar, and this is the table of the content. Consists of fact of the case, issues, judgment, ratio decidendi, dicta, parties argument, and critical comment. Okay, for the facts of the case, a Canadian corporation has owned and operated the Trail Smelter in British Columbia in 1906. The environmental damage caused by one of the state's environment of another triggered the legal claim in this case. The Columbia River begin in Canada and flow past a lead and zinc in smelter in Trail, British Columbia, causing the damage to trees, crops, and lands in Washington, United States. The Canadian company ran the smelter continuously in 1906. It has gradually expanded the plant to become one of the most fully equipped smelting plants on the American continent. In 1916, approximately 5,000 tons of sulfur were emitted per month. The third smelter caused additional damage in Washington from 1925 to 1931. The US government proposed to the Canadian government in December 1927 that the smelter issues be referred to the International Joint Commission IJC. The IJC was asked 5 questions, and then on the February 17, 1933, the US government approached the Canadian government because the existing conditions were unsatisfactory and damage was still occurring. As a result, both parties engaged in additional diplomatic negotiation to have dispute resolved through arbitration. And then the issue for this case is the duty imposed upon the tribunal by the convention was fully decide the following question: whether or not a damage caused by the trail smelter in the state of Washington since 1st January 1932, and if so, what indemnity should be paid. And then the second is it the responsibility of the state to protect other states at all times from harmful acts committed by the individuals under its jurisdictions? In light of the answer of the preceding question, what measures on regime, if any, should the trail smelter adopt or maintain it? And then the judgment of this case, it is state's responsibility to protect the other states at all time from harmful acts that committed by any individual under its jurisdictions. The arbitration panel determined that the Canada, who is the defendant, is legally liable for the action of the trail smelter company. The tribunal determined that the damage occurred between the 1st January 1932 and 1st January 1933, and that the amount of compensation to be paid was 78,000 US dollar. A control regime or measure shall be applied to the smelter's operation because, in the tribunal's opinion, future damage may occur if the smelter's operation are not curtailed. The indemnity or compensation should be paid in accordance with the decision of the tribunal on the two preceding questions. On the part of the ratio decidendi, the court's decision is based on the fact that, as stipulated by the US laws and international laws principle, no state has the right to use or permit the use of its territory in such a way as to cause injury by films in or to the territory of another or to the properties or person therein. The train smelter caused damage in the state of Washington between January 1st January 1932 and 1st October 1937, and the indemnity should be paid is the 78,000 US dollar, which is to be a complete and final indemnity and compensation for all damage that occurred between such dates. As a result, the indemnity for damages should be determined by both government in accordance with the Article 3 of the existing treaty between the two countries. In relation to this issue, since the tribunal decided in its previous decision that damage caused by the trade smelter has occurred in the state of Washington since 1st January 1932, and because the tribunal believed that damage may occur in the future unless the smelter's operations are subject to some control in order to avoid damage occurring.
Hi, my name is Anwar Uthman Hakim bin Anwar and my metric number 054461. So I will continue to present about the dicta of this case. The tribunal determined that Canada should pay the United States $75,000. However, this judgment is effectively an arbitrary dicta because the Canadian government had already announced that it would pay any loss incurred as a result of the smelter. Between 1931 and 1937, each government deployed automatic sulfur dioxide recorders based on a trial conducted in the United States. At the Washington, Canada, the effect of sulfur dioxide fumigation on plant life and crop productivity. So, experts on both sides and non-expert witnesses testified about the real state of the crop in the field. Experimental tests of the sulfur content of the soil and streams in the vicinity were conducted by the both parties because the witnesses were unintentionally biased, resulting in competing opinion and conclusion. The evidence offered by the expert and witnesses was insufficient for the tribunal to determine the source of loss in confidence. So the tribunal concluded that spying had caused damage. So for the practice argument, based on the United States or a plaintiff, the plaintiff lawyer claimed that the pollution caused by smelter company from Canada affected the crops and forests in the United States, and that because mostly Americans were a farmer and a landowner, they were affected by the pollution. This is due to the trail proximity to the Columbia River, which has a north port to the south of it. As a result, the plaintiff contended that defendant's damage was irreversible injury. The expert conducted a survey and experiment which revealed that injury was the cause by the presence of the sulfur dioxide gas from smelter smoke. Uh, uh, Next, we move to the Canada or defendants. The defendant's lawyer argued that the company had paid several compensation each time when U.S. resident complained. The defendant lawyer even tried to narrow the definition of the theory of invisible injury and was successful. The defendant like the plaintiff retained expert to determine whether the damage to the crops and forest was caused by the company. So for the critical comments, it is generally accepted the most important principle in the international community is that one country should not interface with the internal affair of another. Sovereignty is the term used to describe this principle. In order to determine environmental issue, we believe that there is a very thin line between right and wrong. In this case, the court applied the no harm principle to decide on the pollution issue. This is relevant when a country pollution directly affect another, as determined in this case. However, this principle applies to direct pollution caused by a state, whereas in reality indirect pollution occur in more horrifying ways, such as emission of harmful gas like CFC, carbon monoxide, and sulfur dioxide. This method has been a potential to harm the environment on the larger scale, for example, the tightening of the ozone layer and the greenhouse effect. Unfortunately, while many countries are aware of the problem, it is extremely difficult to regulate. This due to the nature of this type of pollution, the concept of sovereignty and the economic development process of a country. As a result, the internal body conclude that the only way to control indirect pollutions is through a region convention such as a Kyoto Protocol and the Paris Agreement. However, it is nearly impossible. Thank you.